Hello, my name's Kate Ellis and I head up the branding group at Connexo UK. In the next few minutes, I'm going to talk about how you can make your mark in a post-Brexit world. In January 2020, the UK and EU ratified the withdrawal agreement. This agreement allowed the UK to depart the EU on 31st January 2020 and for a transition period to begin. The transition period was intended to allow a smooth departure for the UK and is due to end on 31st December 2020. During the transition period, EU law continues to operate in the UK and the trademark and design systems have continued and will continue to do so until the end of this year. However, after the end of the transition period, Brexit will have important consequences for trademarks and design rights in the UK. In brief, there are 4 key points. 1. EU trademarks and community registered designs will no longer cover the UK after the end of the transition period, but the UK will automatically create comparable UK registered trademarks and registered designs, effectively cloning the EU rights into UK rights. And the good news for brand owners is that no further action will be required by them in terms of this cloning of existing EU registrations. Secondly, applicants of pending EU trademark applications and community registered designs that have not proceeded to registration by 31st December will then have 9 months to apply for comparable UK trademarks, claiming priority from the pending EU applications. However, further costs will be payable for the UK applications to proceed. Thirdly, UK-based entities will not be able to own .eu domain names after we depart EU. Fourthly, over time, some areas of law will inevitably start to diverge from the EU. An example includes the quite recently adopted Digital Copyright Directive, which the UK government has stated it has no plans to implement in the UK. So, ahead of the UK's final departure from the EU, there are a number of steps which brand owners should now be taking. Essentially, there is a 10-step plan. First, you should be reviewing your existing IP agreements and licenses. The wording of agreements may require clarification or may not provide the necessary rights following Brexit. As such, all IP-related agreements should now be reviewed to ensure that they are sufficiently clear in relation to IP usage, rights and territories. But any required changes may well be minor because UK legislation has been enacted, which makes it clear that 1. Consents and licenses which cover the UK prior to Brexit should still be treated as covering the UK after Brexit, even in circumstances where the licence is expressed to cover the EU. Secondly, references to EU trademarks and community registered designs are to be treated as also making reference to any comparable UK rights that are created post-Brexit. You should now be reviewing the wording of any IP agreements that are under negotiation and which will not be completed by 31st December. Agreements which are currently under negotiation should be drafted to ensure that they are clear on the position after the end of the transition period. This is particularly important since the UK legislation which I have just mentioned only applies to agreements that are in force at the end of the transition period. Thirdly, you now need to be reviewing ownership of your .eu domains. UK-based individuals and companies will not be able to own .eu domains after the UK leaves the EU. As such, the ownership of any .eu names should be reviewed now, and it'll be necessary to consider whether they can be transferred to an EU-based group company. Otherwise, it will be necessary to consider other options, such as the registration and transition of a website to a non.eu domain name. Fourthly, you need to be reviewing any EU customs notices. Currently, IP owners can file a single application which can cover the whole of the EU to prevent counterfeit goods from entering the UK. Post-Brexit, IP owners will need to file separate customs applications in the UK and the EU. Accordingly, applications which have been filed via UK customs will no longer take effect at the EU borders at the end of the transition period, and IP owners should file a further application through the customs authorities of another EU member state. Fifthly, you just need to check that your current trademark attorneys can continue to represent you at the EU IPO post-Brexit. In this regard, UK-based trademark attorneys will not be able to represent clients at the EU IPO post-Brexit as currently planned. As such, IP owners will need to consider whether their existing IP legal representatives will remain entitled to represent them before the EU IPO when the transition period has ended. Sixthly, you need to be reviewing the impact of any ongoing EU IPO actions. Once the UK leaves the EU IPO has confirmed that it will disregard UK trademarks and other rights that have been relied on in any opposition or cancellation proceedings which were filed prior to Brexit. This means that any actions which are only based on UK rights will fall away, and parallel actions against the new comparable UK trademark may need to be brought after 31st of December. As such, all ongoing proceedings should be reviewed to check whether they are based on UK rights only. If so, steps should now be taken to conclude those disputes prior to the end of the transition period. Seventh point, you now need to be considering whether you have sufficient EU trademark protection in place post-Brexit. From 1st January 2021, you will not be able to rely on UK trademarks to oppose EU trademark applications. As such, even if, as a defensive registration, you should be considering securing EU trademark protection for any brands where you only currently have UK trademark protection in place. Eighthly, you need to be considering whether there is any action which will need to be taken after the end of the transition period. So if you have any EU trademarks or community registered designs which are pending at the time the transition period ends on 31st December 2020, it will then be necessary to refile the applications in the UK, claiming priority from the EU application in the 9 months following the end of the transition period. This will require the payment of filing fees to the UK IPO. Ninth step, you need to consider whether you need to file any equivalent cancellation or opposition actions in the UK. As I've mentioned, immediately following the end of the transition period, any pending cancellation actions against EU trademarks and community registered designs, and any oppositions against EU trademarks which are based solely on UK rights should be reviewed, and you'll need to consider whether it's necessary to file equivalent actions against the comparable UK right that will be automatically created. And finally, number 10. This relates to the recordal of security, licence and other interests. So where security, licence and other interests are recorded against an EU right, IP owners will need to consider whether to record these corresponding interests against newly created comparable UK rights. If these interests are to be recorded, then any assignment or grant of the right to third parties will then be subject to those recorded rights. If you do need any further guidance in terms of the impact of Brexit on your trademark and design right portfolios, then please do not hesitate to get in touch.